Hello, everyone. I'm Kevin Karanka. I'm a partner in Husch Blackwell's Austin office and its labor and employment group. Welcome to the firm's annual Texas Legal Update. We're back this fall with our virtual seminar series, and we're glad to have many attendees from across the state of Texas and many other places joining us today. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit those via the question box. We will try to do our best to answer all questions during the webcast today, but if a fuller answer is needed or if we just run out of time, we'll make sure to follow up with you after the seminar to answer your questions via email instead. A PDF copy of the presentation and related materials today are available in the resources folder at the bottom of your screen. This program has been approved for HR and legal education hours. To report these hours, click on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We value your input to the survey that allows us to generate content tailored to your needs going forward. That's it for our housekeeping items, so let's go ahead and get started with our program. Just a brief overview, we will have 5 sections of content today. All 5 will be about 15 to 20 minutes in length, so please be sure to take a break as needed within the program because we will not be taking breaks as we go. Given that we're in the middle of October and it's finally starting to feel like fall here in Texas a little bit, we'll be sprinkling in some fun facts about our presenters and their favorite things about the fall or the Halloween season. So first up, I want to introduce Aissa Maldonado and Cooper Page. They're going to kick off our program with a legal update on recent changes in Texas law over the last 12 months. Fun fact about Aissa, she just started in our Austin office. She works here with me, and she graduated from Texas Tech earlier this year. But even more interesting, when she was younger, Aissa played a zombie at a local haunted house during a Halloween. It was one of her first jobs. Cooper is a labor and employment lawyer in our Dallas office. Fun fact about Cooper, growing up, his favorite Halloween costume was when he dressed up as a bumblebee as a baby, and poking a little bit of fun of himself. Cooper told me, even more interesting, he still has the same haircut now that he did when he was a baby. So check it out whenever you get a chance when we switch over to Cooper and Aissa, and I'll turn it over to them now.
Good morning. As Kevin mentioned, my name is Aissa, and I'm an associate here at the Austin office. The first case we'll be talking about today is a hostile work environment claim out of the Fifth Circuit. This claim focused on the wording of an African-American employee's complaint that his supervisor called him a racial epithet during work. Title VII is a federal employment law that prohibits employment discrimination based on race, color, religion, sex, and national origin. In order to create a hostile work environment claim under Title VII, the conduct at issue must be sufficiently pervasive and severe. And as a general matter, a single use of a word or phrase is not enough. At the trial court level, the trial court dismissed this case on that same basis, that a single utterance could not support a hostile work environment claim. However, the Fifth Circuit disagreed with the trial court, and in reviewing decisions from courts across the country, the Fifth Circuit determined that no single word can more quickly alter the conditions of employment and create a hostile work environment than the utterance of the N-word by a supervisor in front of subordinates. The court ultimately held that an employer can be liable for such a claim if it knew or should have known of the harassment and failed to do anything to remediate it. The employer takeaways from this case is that one incident can be actionable if it's sufficiently pervasive and severe. It's important to maintain anti-harassment policies that provide sufficient avenues for employers to create complaints so that management can address. And it's important to investigate and take prompt action if such a situation would arise. The next case we'll be talking about is a gender discrimination case, also out of the Fifth Circuit. The Fifth Circuit affirmed summary judgment in favor of the employer despite its recognition that the former employee had presented substantial evidence that the stated reason for termination was false. In this case, the court addressed the complaint of a senior female manager who complained about sex discrimination in her workplace. The plaintiff claimed to have reported it to her boss, and 6 weeks after receiving the complaint, she was placed on a performance improvement plan. Owens worked for Circassia Pharmaceuticals for about 8 years when her employer discharged her just 3 days short of her performance improvement plan expiring. Despite having solid work performance reviews and her sales team consistently being rated amongst the top in her company of the country, she was terminated. Owens was an Asian female who was replaced by a coworker who was a Caucasian male. Therefore, the primary issue in this case was that of pretext. When determining whether a plaintiff's disparate treatment claim should survive a defendant employer's motion for summary judgment, the courts will apply a burden-shifting analysis. First, the plaintiff must prove a prima facie case of discrimination, which means that she must prove that she's a member of a protected class, she was qualified for her position, she was replaced by someone outside of her protected class, or someone who is similarly situated. The burden then shifts to the employer to prove a legitimate, non-discriminatory reason as to why the employee was terminated. And once the employer can prove that, then the burden shifts back to the plaintiff to prove that, or with substantial evidence, that the defendant's reason was actually pretextual. The court held that employers are entitled to be unreasonable in terminating employees as long as they do not act with discriminatory animus. In this case, the employer takeaways are that it's important to document reasons for termination. That way, if such a dispute would arise, you have documentations of the legitimate reasons. This is also a reminder of the employee's at-will status, and it's important to ensure that when terminating employees, employers don't do so with discriminatory animus. Next, we are going to Houston, and there's another case out of the Fifth Circuit, which is a national origin and sex discrimination case. In this case, the Equal Employment Opportunity Commission, or the EEOC, sued Ryan's Point Houston, which is an apartment agency in Houston, on behalf of a pregnant property manager of Mexican descent, Magali Villalobos. The agency alleged that the employer terminated the manager as part of their attempt to cater to a higher class of residents. The EEOC also introduced testimony that the property owners referred to Mexicans in derogatory terms and told the regional director that they wanted a more Ken and Barbie feel of employees at their apartment complex. Finally, the EEOC alleged that the owners expressed frustration over the manager's pregnancy, allegedly advised her to get an abortion, and claimed that Mexicans always took their FMLA entitlement. The district court dismissed the suit on the basis that these remarks were just stray remarks and that the employer demonstrated legitimate reasons of performance deficiency with the manager's work regarding delinquent rent payments. However, when the Fifth Circuit took this case, they reversed the dismissal and remanded the suit for jury trial should the case not settle. The court noted that the remarks presented by the EEOC were direct evidence of discriminatory intent, and in fact, there were no performance deficiencies, and that Magali actually improved delinquent rent payments. The employer takeaways from this case is that it's important to document performance issues as they arise. It's important to ensure no discriminatory animus when you are terminating employees, and it's important to be aware of paper trails and actions of supervisors, and to advise employees that to be careful what they say when they are communicating internally about employees. And I'm going to hand it off to Cooper.
Thanks, Aisa. Yeah, I'm Cooper Page. I'm an associate in our Dallas office. Do want to be clear, I did not give Kevin permission to make bald jokes today, so I resent that fact. Next case that we're going to talk about here, case of Goff v. Holden and Charter Communications. For those of you who haven't seen this, has made headlines out of Dallas recently with a record-setting verdict of over $7 billion in compensatory and punitive damages, recently reduced down to $1 billion. But some sad facts in this one we'll touch on briefly. So this is a case where an employee of Charter doing business as Spectrum was installing internet and cable services in customers' homes. A lot of different moving parts and factors that went into this one, but he ended up returning to a customer's home and robbed and killed her after he had performed services there. So he was confessed and was charged criminally, but then the family also brought a negligent suit against his employer. So a few different things to talk about, and we'll actually talk about some of the warning signs and factors that you can consider for employees like this in a later presentation. But the court did touch on background checks and employment verification checks. So Charter did run a criminal background check that was verified, which is standard and should be done by employers in hiring decisions. They also had an employment verification process, but it was a self-reported process. And so the employee self-reported past jobs, a few he omitted, and led or gave some false information. And so the court actually suggested that, especially in jobs like this, where they're entering customers' homes and have that sort of close relationship with customers, that it should be a verified employment check and make sure that you have all that necessary information, because he had been fired for forgery, ignoring supervision, some unprofessional conduct, and things like that in the jobs that he admitted from that verification. Also, a good reminder that employers can be liable for what their employees do in their scope of work, but also can be found liable for negligence even outside of the scope of work, which was the case here. There's also some evidence presented that the employer forged documents to try to bring the case to arbitration. So obviously that want to make sure that have all the documentation in place and don't do anything improper on that front. Next one we're going to talk about here is the WARN Act and how COVID-19 plays into that. This was the case of ESOM v. U.S. Well Services Incorporated. And so the WARN Act, for those of you who aren't familiar, is a federal statute that requires businesses to provide warnings of closures and layoffs in certain instances. Typically, it's if it's a full plant closing or if there's a large portion of the employment population that's being laid off. And there's a few exceptions to that rule. So the WARN Act requires 60 days notice of a plant closing or mass layoff. Some exceptions to that rule include if the business is faltering, unforeseen business circumstances, or a natural disaster. In this case, the employer alleged that COVID-19 pandemic was a natural disaster, so they weren't required to give those 60 days notice. And the court disagreed, said that the clear language of the statute suggests that natural disasters are hurricanes, tornadoes, fires, things like that, and that a pandemic wouldn't fall under those circumstances. So important to remember that if there are layoffs or closings moving forward and how the WARN Act might apply. Many states too have what we call mini WARN Acts or state-specific WARN Acts that can come into play. So for those of you that have operations outside of Texas, want to be sure that you're aware of those things as well. And then of course, COVID-19 could potentially be an unforeseen business circumstance, which is another exception to the WARN Act, but that's a fact-specific inquiry, and that's not what the employer alleged here. So Fifth Circuit was the first circuit that decided that under the natural disaster exception to the WARN Act, COVID-19 does not apply, or other similar pandemics. Want to touch a little bit on arbitration agreements here as well. There's a few interesting cases both on the Texas and national level. Seems like this is an area of the law that's always moving and changing, so important to get a little update here. First one was a class action brought against Tesla here in the Austin area, and the crux of the claim is actually a WARN Act violation. They allege that Tesla failed to comply with the federal WARN Act when they laid off a number of employees. But the issue that was decided recently is the enforceability of those arbitration agreements and who should actually decide whether they're enforceable or not. So obviously, as an employer, if you have an arbitration agreement signed, you want to make sure that they're enforced and followed by the employees. But a preliminary question is whether, if a case is brought in court, federal or state court, whether that judge will make the decision or whether an arbitrator should make that initial decision of arbitrability. And so this magistrate judge decided that it should be an arbitrator, that the arbitration agreement was clear on that front. So that's a good reminder, too, to make sure that your agreements are clear on who should decide that initial question of arbitrability before you get into the heart of the claims. The Indian Forced Arbitration of Sexual Assault and Sexual Harassment Act was passed. Rare one that had bipartisan support. I know that seems unique these days, but this allows employees subject to arbitration agreements to void those agreements and pursue sexual assault or sexual harassment claims in court. And so this was passed on the federal level. And so even if a valid arbitration agreement is executed between an employee and employer, if those claims are for sexual assault and sexual harassment, then they can be brought in court. And so we saw a big push towards arbitration agreements over the last few years and decades, but seen that drawn back a little bit now. And so the Biden administration and the current legislature passed this act that said if it's a claim for sexual assault or sexual harassment, they should get their day in court and not be forced to go to arbitration. We see states passing similar laws with confidentiality clauses or non-disparagement clauses that say that those shouldn't cover claims like this that are important and deserve the publicity that they can bring. And so there's a shift back from arbitration in some of these cases. Morgan v. Sundance, Inc. It was another unanimous Supreme Court decision. And so this case dealt with how federal circuits deal with claims for arbitration. So this was 8 months into litigation. Employee had brought a claim, and the employer sought to dismiss, which was denied, and then filed an answer. And then 8 months later, decided that they wanted to enforce this arbitration agreement. And so a lot of federal circuits had a unique standard for enforcing arbitration agreements. And so the standard was that they must have acted inconsistently with their right to arbitration, and there also must be a prejudice to the employer, to the party that brought the claim. The Supreme Court said that prejudice element should not be in place anymore. And so while that rule was enacted because the FAA encourages arbitration, the court said that arbitration agreements should be treated the same as other contracts. And so that extra element that there has to be a prejudice to the employee is not proper and should not be the standard that federal circuits use. So moving forward, if you do have an arbitration agreement in place and a claim is brought, want to make sure that you enforce that immediately, because an employee will only need to show that the employer acted inconsistently with that right to determine that arbitration agreement is void in that case. Finally, I want to talk about employee commissions a little bit. This was a Texas case of Pertius v. Baylor Laboratories, LLC. And so this dealt with commission plans that you often find in employee handbooks or policies or in an employment agreement. In this case specifically, this was a VP of sales, and the agreement that they had only said that his commission would be 3.5% of the sales. There was not any additional facts or information added in that employment agreement. Now, there was, of course, patterns and practices of what that employee and employer did. So he had secured a sale, contract was being drafted, was in the process of finalizing that sale that he would earn commissions on. I believe it was the largest commission that he would have earned for that year in that company's history. And he was terminated. The day after he was terminated, the contract was finalized and then payment was secured later. And so this case decided that if those terms aren't clear in your commission agreement, then you can't withhold the commission from that employee. So want to make sure moving forward that your commission plans are clear about when commissions are earned. And so if you want to say that commissions aren't earned until payment is received or until the lines are crossed and signatures obtained on those commission agreements, that's fine, but want to make sure that you do that clearly in the agreement and set that out. Also talked about that commission plans may only be modified in writing, and so verbal agreements won't hold up. And so if there isn't clear language there, then the court will revert to the procuring cause standard, which has been from a Texas case dating back to 1916, saying that if you are the procuring cause of that sale, so but for that employee, the sale wouldn't have been made. And so that's what the court relied on and decided that he was owed commissions in that case. That wraps up our Texas legal update, and so I'll send it back to Kevin.
Thanks, Cooper. I guess that's really interesting in terms of the charter case. I think that's definitely something that's sure to give employers around the state a scare, even though it's not quite Halloween yet. And on that note, we'll go ahead and pull up our first poll question to make sure you guys out there in the audience aren't nodding off. So question number one, on Halloween, would you rather A, go trick-or-treating, B, bob for apples, C, stay home and watch a scary movie, or D, tour a haunted house? So you guys go ahead and put your answers in there, and we'll give you a few seconds for the answers to come through and see what everybody's favorite is. We do have an interesting story about bobbing for apples coming up later in the presentation, but I don't want to influence anybody's vote. Okay, some more answers are trickling in, and it looks like close for first and second. First is C, stay home and watch a scary movie. That'd probably be my favorite as well. Or the second favorite looks like lots of folks picked go trick-or-treating. I wonder if that's as an adult or with your kids. That's always interesting to see adults wandering around the neighborhood by themselves. But anyhow, turning on to our next topic, we've got Eric Dama and Andrew Caton, both out of our Dallas office. They're going to discuss how Texas's new sexual harassment laws may impact our clients. Eric and Andrew are both labor and employment lawyers as well. Eric's favorite Halloween costume growing up was when he dressed as T-Rex. And Andrew's favorite costume was when he dressed up as Skeletor, the bad guy from He-Man and Masters of the Universe, which earned some brownie points with me. But he also shared with me that one of his favorite Halloween candies is the highly questionable Almond Joy, which knocks him down a few pegs in my book. So maybe he can redeem himself with this presentation. With that, I'll turn it over to Andrew and Eric.
All right, thank you, Kevin. Good morning, everybody. My name is Eric Dama, and I'm joined by my colleague, Andrew Caton. As Kevin said, thank you very much for joining us for this session. We are here to discuss the new sexual harassment laws in Texas. And of course, these aren't entirely new. These are the ones that are very significant and went into effect in September 2021 of last year. But given that it's a little over a year since the laws went into effect, and a lot of us are still waiting on some of the court cases, decisions and interpretations to come down to provide some clearer guidance on how we can respond to these laws, we did feel it was a great opportunity and a very important opportunity to be able to not only discuss each of the specific changes, but what also employers should be, and hopefully have been doing in response to the laws. So without further ado, I'm going to turn it over to Andrew.
Thank you, Eric. In thinking about these new sexual harassment laws here in Texas, I think it's best to help first understand where we came from. Under Title VII and the prior version of the Texas Labor Code, sexual harassment was treated as a subset of sex discrimination. And what the Texas legislature now has done is essentially taken the issue of harassment and made it an independent section of the Texas Labor Code. I think what's part of interesting is in the language of the code, section 21.141, it really takes the prior case law and also borrows from federal code regarding the definition of what is sexual harassment. And quite frankly, it borrows the language quite directly. And it says that it's unwelcome sexual advance, request for sexual favor, or any other verbal or physical conduct of a sexual nature. If the submission to the advance request or conduct is made to term or condition of the employment, whether it's implicit or explicit, whether submission or rejection of the advance is used as a basis for an employment decision affecting the employee, whether the advance request has the purpose or effect of unreasonably interfering with the individual work performance, and whether or not the advance request has the purpose or effect of creating an intimidating, hostile, or offensive work environment. Now, those words are pretty much chosen and pulled directly out of case law and also out of 29 CFR section 1604. And so in that way, we can look at and understand that interpretation, and by the legislature taking that out and making it an explicit definition in the state of Texas, we're taking a really harder look at the issue of sexual harassment and really making it separate and disparate from, not disparate, but separate from the actual issue of other discrimination claims. And when you consider the sort of insidious and coercive nature of sexual harassment, it does make some sense that maybe we need to take a little bit more aggressive look at how we can kind of address and handle those claims. It does a couple of things, as you see on the slide. It does reduce the number of employees that a company has that falls under the law. It's pretty much all companies, but we'll touch on it in more detail. The actions that are required of the employer revert from a prompt and remedial action to an immediate and appropriate corrective action. And it changes the deadline that an employee would have to file their claim with the EEOC, with the Texas Workforce Commission, and it also provides some individual liability to the actual harasser. So, but we'll go into each one of these sections in a little bit more detail. And so with that, I'll pass it back to Eric.
Thanks, Andrew. And yeah, that context too is very interesting, because I know these laws are important and significant for a variety of reasons, but especially in Texas when, we generally think of Texas as a more employer-friendly state. And so anytime Texas passes laws that go above the federal threshold, it's always going to be noteworthy. So, but as Andrew mentioned, so one of those new laws was extending the deadline that employees have to file their charge of discrimination, specifically alleging sexual harassment, with the TWC, the Texas Workforce Commission. Now, before I go any further, I should mention, so the title of the slide there says time, not as much, ? Of the essence. And so that is really meant to be from the employee's perspective, of course. I think hopefully, if you take away anything from Andrew and I's presentation this morning, it's that at least for the employer, time is going to be very much of the essence. It will be absolutely critical under these new laws, and certainly until we get a little bit more guidance. But at least from the employee's perspective, they're going to have a little bit more time now to file their charge of sexual harassment under state law with the TWC. The old deadline used to be 180 days. Now it's 300 days. And kind of similar to our discussion about Texas being either above or in line with the federal laws, this brings Texas, at least with respect to sexual harassment, in line with the EEOC deadlines of 300 days. Now, there's a couple interesting things that we should note about this. First of all, this extension does not apply to any other discrimination claims or retaliation claims. It's specifically limited to sexual harassment. And even more so, on the retaliation front, it does not apply to claims of retaliation for reporting sexual harassment. So, in essence, this may actually present, well, it's something to be on the lookout for, but it certainly may present some problems for employees going forward. I think what you often see is employees will typically wait to bring all of their claims if they have, let's say, combined claims. So not only allegations of sexual harassment, but some other form of discrimination. And then, or let's say sexual harassment as well as a claim for retaliation. If it's kind of based on the same general underlying facts and conduct, you typically see the employees wait to bring them all at the same time. And now under these new laws, though, if they were to do that and only bring those to the Texas Workforce Commission, they could run into issues there with those other claims being time barred. So it's going to be especially important to scrutinize the timing of all of the alleged conduct and also what specific claims the employees are bringing. That's some information, at least. These laws, these changes to the deadlines are going to, I think, probably have the most effect on the employee. So as far as who's an employer or some of the other effects on the employer, I'm going to turn it back to Andrew to discuss that.
Thanks, Eric. So a very important change in the law is which employers it's applicable to. Under Title VII in the prior version of the Texas Labor Code, all of those claims, discrimination claims, were applicable to those employers that had 15 or more employees under the applicable time periods and standards. In this case, when they separated out sexual harassment to be selectively dealt with, they included all employers, even those employers with only one employee. And you can envision, without taking too much away from Eric's next slide, even those, because it does also apply, it does give personal liability to those acting directly in the interests of an employer. In relation to an employee, you can think of an individual who might be a solo consultant of some kind. Personally, I have a background in oil and gas space, and it's not uncommon where you might have a work site that have multiple different companies, and there might be a consultant as an individual who controls and manages that site. And so you can readily envision a bit of a hornet's nest that could come up, that if it's not just those supervisors and managers for a particular employer of the employee, but it's anybody that acts directly in the interest of the employer in relation to that employee. So there can be a little bit of a hornet's nest that we can imagine that is going to creep up on this. And unfortunately, we don't have any court cases yet to be able to understand how the courts are going to be going to interpret this. But what I do think is really important and an important takeaway is because the legislature has taken this out and made it a completely separate section of the Texas Labor Code, I think we can expect that the Texas workforce or the courts are going to take a harsher look and the standards are going to be more rigorous for those particular employees that are facing these kinds of claims. Now, one thing that is a little bit interesting here is, there is a separate section of the code that's related to franchisees and franchisors, and specifically, it kind of excludes from the definition of an employer those franchisors would not necessarily be liable to those employees of a franchisee. But with this separate section being pulled out for sexual harassment, to the extent that there's a seconded employee or a borrowed employee where the franchisor and the franchisee are acting together, whether or not that second part of this definition of an employer, which acts directly in the interests of an employer in relation to the employee, it brings into question whether or not that franchisor-franchisee relationship with respect to the code could also get some additional scrutiny by the courts. So with that, we'll have Eric talk a little bit more about the expanded liability to individuals.
Thanks, Andrew. And that's exactly right. And I think the examples you provided are a really good perspective and a needed perspective until we get, more guidance. And that's really what we're awaiting. And this question of, well, what does, who could be a person that falls under this definition of acting directly in the interests of an employer? And so, we talked about this a little bit earlier, and pardon me. But so there actually are some federal laws, specifically like the FLSA and others, that have similar phrasing in terms of this idea of acting in the interests of an employer. And those, generally speaking, those federal laws have been, courts have interpreted those more narrowly in terms of, the employer, or excuse me, the individual needs to have more than just supervisory power to trigger the application of the definition. Can be a variety of factors or tests, or something such as additional hiring power or firing authority, or even the ability to make or adjust compensation. And so that's not to say that we know, or that we necessarily expect there to be a narrow interpretation of this particular definition as it relates to the new Texas Labor Code amendments. But it is to say, until we know more, certainly until we have more guidance, I think it's most prudent to read a broad, read that definition as broadly as possible. So as far as who that could entail, as you'll see on the screen, I mean, I think certainly it's at least safe to say supervisors and managers, officers, directors, potentially perhaps even, human resources personnel or coworkers. And then also, of course, as Andrew discussed, some of the third parties. So I think in consideration of this, there's a few important steps that employers can take. Number one, it's to inform supervisors and managers of the potential that they could be held individually liable under these new laws. It always helps to increase training, and I don't know that I would call it a motivator necessarily, but I think really employers could use that prospect of potential individual liability to really underscore and stress the importance to these managers, the importance of acting swiftly and immediately to report any complaints. The other thing I think, kind of in conjunction with that, is the reporting itself. Increased training helps, certainly periodic training. And one of the things that you want to do is make sure, though, that not just these individuals we've talked about, but that all employees are aware of all of the available reporting channels, that they're clear and defined, and of course that there are alternate channels, so that they can go ahead and also immediately report any complaints. So I know I've used the word immediate a couple times here, and I'm not trying to steal Andrew's thunder, but he's going to talk a little bit about what I alluded to earlier. I think probably the other aspect of this law that we're most eagerly awaiting interpretations on.
Thanks, Eric. So I think a really important change that we need to consider with respect to sexual harassment, and again, this change is specific to a claim of sexual harassment, not necessarily any other claim of discrimination under the Labor Code, and that is the requirements and how an employer is going to be scrutinized and what actions it took to remedy the sexual harassing behavior. And under the prior Texas Code, the prior common law and the federal law was that an employer needed to take prompt and remedial action to try to avoid liability in the instance of a sexual harassment claim. And just as we've seen earlier where the legislature specifically adopted prior existing language, the legislature has now taken different tact and required immediate and appropriate corrective action instead of simply prompt and remedial. Now, what does that mean? Well, I think we can all take out a thesaurus and conclude that prompt can very well mean immediate. Remedial can very well mean corrective action. So what's the difference? I think that given the insidious nature of sexual harassment and the legislature's intentional changing of the language, I think we can conclude that courts are going to scrutinize employers a lot more harshly in deciding whether or not and to what extent that an employer has tried to correct the harassing behavior on behalf of the employee. Now, there is no requirement for an employer to be proactive in these measures. I think, I'm sorry, I'll go back for just a moment. And I guess in understanding the immediate and corrective action, it's, I think, a good definition that I've pulled was there's a temporal or a time connection between the date of the harassment, the timing of the response, and the sufficiency of the investigation once the company knows about the harassing action. So, as Eric mentioned earlier, to the extent that a robust investigation of any claims is brought forth, training not just of your own employees and supervisors, but if you have independent contractors who have some supervisory function, they all need to be aware, and if they become aware of issues of sexual harassment in the workplace, and they need to be able to report that back to the company to make sure that the appropriate and prompt investigation can continue. Now, there's no requirement to be proactive in this instance to avoid liability. However, I think it's pretty simple advice that whether the employer knew or should have known about the harassing behavior, to the extent that you take training requirements and you do take proactive actions, the more likely that the company management is going to know about those issues and can take that prompt and immediate, not prompt, immediate and appropriate corrective action. And so this will easily probably be the most heavily litigated concept with this new law, how the courts are going to interpret the immediate and appropriate corrective action. But that's something that I think we can certainly say is going to be more aggressive and robust than what is meant by prompt and remedial action.
Yeah, it's interesting, Andrew, that like you mentioned, the legislature chose very specific words, but now we're waiting for the court to kind of tell us what they mean. So we do want to leave you with a few final thoughts. I don't think we had mentioned this, but so conduct still occurring before September 1st of last year, 2021, is still going to be governed by the old laws. And so this, of course, will become less and less, I think, relevant as time goes on. And I mean, we're still even, we're already 300 days past September 1st of last year. But in any event, we just want to emphasize that we're not completely done with the old laws yet. As we've already said, it's something to continue to monitor as the case is developed, hopefully maybe through the end of the year, and they start to come down. But certainly, I would think as we get into 2023, the importance of not only thorough and timely investigation, but contemporaneous documentation and record keeping as well. These things, of course, are, Andrew, always important, but they become even more so now under these new laws. And then finally, as always, seek advice and counsel. If you have any questions, if you are a smaller business that perhaps wasn't covered under the old laws, but now you are, and even if you were covered under the previous laws, but you'd like to, need to revise some of your policies and procedures or training programs, there's a variety of different things that can be done, and it's certainly not one size fits all. So we hope this was helpful, and we thank you again for joining us this morning.
Thanks, Eric and Andrew. Yeah, very interesting. It'll be intriguing to see how courts interpret that new language in the statute and how the case law develops over the next couple of years, though I'm still not sure about that Almond Joy candy choice. But that'll lead us on into our next poll question. Which of these candies, audience members, are you hoping lands in your trick-or-treat bucket this year? A, Sour Patch Kids. B, Reese's Peanut Butter Cups, C, Skittles, or D, M&Ms? We'll go ahead and give you guys a few seconds to log in your choices. My personal favorite is Reese's Peanut Butter Cups, and I'm watching the results filter in. I think most of you guys are going to agree with me, but we'll see. Okay, so the results are in, and as anticipated, B, Reese's Peanut Butter Cups is the clear winner, supporting my thought process there. So if anybody's looking to send me a treat for Halloween this year, you know what my favorite is. But I want to go ahead and introduce you guys to our next group of presenters. Tracy Wolf and Brian Hendricks are going to be talking about gun laws and workplace violence, sort of expanding upon some of the issues that Cooper and Aissa talked about earlier on that charter communications case and other issues that are relevant to that sort of analysis. Tracy is a labor and employment partner in our Dallas office, and Brian is a partner who helps lead up our safety and health group out of our Washington, D.C. office. Fun fact about Tracy, when she was growing up, her favorite Halloween costumes were when she dressed as Cinderella and as Casper the Ghost. But even more interesting is the story that she told me, and maybe she'll share a little bit more about this with you guys, about when she went bobbing for apples one Halloween. She had just gotten her braces on the morning before, and she went under the water to grab an apple and had to go back and see the orthodontist the next day for some cleanup work. Brian has a great Halloween story as well. He shared a story with me about when he was 5 years old, and he just watched Star Wars for the first time, and I think was a little bit scared or worried about Darth Vader. And so one Halloween, he was in the kitchen with his mom, and there was a knock on the door, and his mom asked him to go answer the door because she was busy loading the dishwasher. And lo and behold, who's at the front door but Darth Vader, dressed up in full costume. And Brian freaked out, as you might expect a 5-year-old would do, and ran back into the kitchen and dove into the dishwasher. And it turned out that it was his dad's coworker that had come by the house to show them his new costume. And I don't think he expected to give Brian quite the scare. So with that, I'll turn it over to Brian and Tracy, and you guys take it from there.
Thank you.
Wow, Brian, that explains a lot.
It does. Not my finest moment as a 5-year-old, but
wow.
I've tried to improve since then, become more courageous, stronger.
That's good. That's good. It's important to be strong. Well, we are very happy to be here today, although we're here to discuss a very difficult topic, workplace violence. And we know we've heard a little bit about it already. We're going to go into a little bit further detail and talk about the types of things employers should be looking out for and should be preparing for with regard to what's going on presently in our culture and just in general, what we've seen as recent trends.
Thank you. And we want to say here, of course, we're anti-violence.
Very much so.
Not pro-violence in the workplace or elsewhere, but it is certainly not a new topic. It is certainly not a topic that any of the regulatory agencies or the legal system has not encountered previously. So there is a great deal of information out there. There's a great deal of understanding, but it is evolving. And we know that this involves certain political beliefs, certain political positions. We have strong opinions one way or the other on the causes of violence and what have you. Those are not what we're here to discuss. No. What we want to discuss are practical solutions for employers to these very difficult issues, how to protect yourself as an employer, how to protect your employees, most importantly, from workplace violence, and also to minimize your liability when some of these challenging issues do arise.
Yeah, and we're seeing it everywhere. We've seen a lot. I mean, it's heartbreaking. Just turn on the television. It's become to a point where in many instances we're desensitized to it. You hear about it at schools, universities, recently hospitals, concerts, sporting events, supermarkets, shopping malls. I mean, you name it. This type of thing is coming up all over the place. And this is a topic that is of national concern, but particularly in Texas right now, because on the heels of a very horrible school shooting earlier this year, as well as the issues that a lot of employers have with gun rights and how to balance that in Texas. Because as a Texan myself, I understand, the right to be able to have a weapon. A lot of people feel differently about that. There are a lot of political views about it. We're not here to get into the politics. We're here to discuss the realities and how to best handle that in Texas.
And I will say that it is still important to understand that, thankfully, random mass shootings are still extremely rare. And in most places, violence of any sort is rare. One thing that is surprising, or was surprising to me at least, is that NIOSH, the National Institute of Occupational Safety and Health, it tracks workplace violence and injuries, illnesses, and fatalities caused by what would be classified as workplace violence. And it is one of the leading causes of injuries, illnesses, and fatalities. Almost 2 million employees every year are victims of workplace violence. That was a number that jumped out at me.
Yeah.
I will say, though, that it's important to realize, too, that a lot of the workplace violence is centered in or arises out of certain industries. There are certain industries, and it does make a great deal of sense, for example, in healthcare, where you are dealing with folks who are not at their best in terms of either their mental well-being or their physical well-being. Those are challenging situations for any employer. So what you see is 2/3 of the workplace violence does take place in healthcare. Now, these are some of the numbers you see here. They are high numbers. At least they jumped out at me as being high in relation to the overall numbers of injuries and illnesses in the workplace. But you can
it's
see
shocking. It's overwhelming.
It is, but it is focused. So let's talk a little bit about workplace violence. What is it? How is it, from a regulatory standpoint, defined? And what you see here is OSHA's definition of workplace violence. It says the way that OSHA has defined it is any act or threat of physical violence, harassment, intimidation, or other threatening or disruptive behavior that occurs at the work site. Now, in my experience with advising clients, it usually isn't a definitional problem. We're usually not struggling to define what is and isn't violence. What does arise, though, are those cases where we have threats, threats of physical violence, harmful words, that kind of thing. Now, OSHA's made it clear, and as I see it, this is a good thing, that they aren't interested in, they're not intending to include in their definition of violence that is of a solely verbal nature in any future regulation that OSHA promulgates. So I am of the opinion that threats are words, they're not actual violence. There are other people who would disagree.
I see you motioned over to me. The words can definitely incite and can be the impetus of
we
that
agree
sort of
there.
action.
That's right, we agree there. And frankly, those difficult cases that we've encountered with clients are cases where it has been all verbal. There have been verbal threats. Verbal threats, concerns about mental health, that kind of thing. And understanding when those threats are actually going to be turned into physical acts. One way to think about this is the way that NIOSH has thought about it or has categorized it. And there are different types in the NIOSH definition or categories of workplace violence that may help you with this. Is there criminal intent and that's rare. You don't normally see that category. What isn't rare, though, is worker-on-worker or personal relationship violence. And those types of situations are the situations that we see more frequently with our clients, where you have two people who are in a verbal confrontation that then turns physical in the workplace, or you have a personal relationship issue that spills into the workforce, not with a coworker, but with someone outside the workforce who then returns to the workforce or comes to the workplace. OSHA and workplace violence. I mentioned that OSHA is looking at regulating workplace violence. It hasn't yet, though. It has not promulgated any specific regulation on workplace violence. There isn't a specific workplace violence standard. However, and this is very important, there is extensive guidance that both OSHA, NIOSH, and other third parties have published on workplace violence and how to avoid it, how to deal with it, policies that you can adopt, actions that you can take. There is an extensive world of guidance and literature out there that you can look to, particularly if you're in one of the industries, one of the specific industries that you see this workplace violence arising in: healthcare, retail, the taxi industry. Those are three that OSHA spends a lot of its time focusing on with its guidance. Now, that doesn't mean that OSHA can't or won't cite you if you have an incidence of workplace violence. OSHA can and will continue to cite employers for workplace violence incidents under OSHA's General Duty Clause. In the General Duty Clause is basically OSHA's catch-all for hazards in the workplace that do not or are not addressed by a specific standard. The hazard has to be, though, recognized by the industry or by the employer. It has to have the potential to cause, or it must be causing death or serious physical harm in the workplace. And this is very important as well, the employer must have failed to address or mitigate the workplace violence through feasible means. And I just want to refer back here, when you're thinking about liability under the OSHA and under the General Duty Clause, the way to avoid this, the way to avoid liability is to follow the guidance that NIOSH and OSHA has published on this. If you're in an industry that isn't known for violence, or where you aren't likely to have a violent incident in the workplace, having a policy and following it as most human resources professionals would, following up with employees about concerns that they have, either about their own mental well-being or about threats or conduct in the workplace. That is and will go quite a long way to protecting you as an employer from a liability standpoint. Treating concerns raised by employees or about other employees, treating those concerns seriously, documenting them, and taking action consistent with the guidance. Really, that is quite a lot of what OSHA can expect of an employer. I won't say the most that OSHA can expect, but it goes quite a long way. Now, OSHA doesn't have a regulation. It is likely to promulgate a regulation at some point. Its work is underway. Texas is not a state-planned state, meaning that federal OSHA is the entity that regulates and enforces occupational safety and health laws. Other states have state plans where the state itself is, in essence, regulating occupational safety and health. Texas is not one of them. Other states do have specific regulations. And federal OSHA looks to those regulations as templates for its future regulation. But here in Texas, the General Duty Clause will be the mechanism for enforcement, at least in the short term.
And with that, let's kind of switch gears a little bit. We've heard a lot about NIOSH and OSHA. Let's talk a little bit about Texas. But to start us off, I'm sure many of you are aware of the Bipartisan Safer Communities Act of 2022. There's been a lot of talk about it. I know for some people, they don't feel it goes far enough. Others kind of think it's overreaching. This is very new. And a lot of this comes on the heels of once again, some shootings and some violence that has happened nationally. A lot of talk about gun sales, gun laws, and how to best approach it. Now, the first major federal gun legislation was, or this is the first a significant change since the federal assault weapons ban of 1994. There's a lot of focus on children and on families and on mental health issues. A lot of this goes to background checks and different provisions that are going to have to be followed by firearm sales individuals. It also criminalizes straw purchases. Now, moving ahead, I think we're getting a little bit ahead here on the slides.
Sorry.
That's okay. That's okay. I'm gonna take the wheel here for a second and try to figure out back where we are. All right. Up. Are we going backwards? Okay. Well, I'm just going to move right along. Let's talk a little bit about gun laws and Texas specifically. One of the projects our firm took on this year, we did a 50-state survey to kind of determine where we are with regard to various laws nationally across all states. In Texas, we're going to highlight a lot of that today. I'm trying to get back, and it may just be that we're missing some of the provisions on our PowerPoint, and that's okay. We can just go ahead and carry on with that. These things happen sometimes. What we have looked at is certain provisions such as red flag laws, parking lot laws, and what employers do with regard to an employee's ability to carry and to have various weapons, particularly guns, on work sites. Now, the red flag laws are laws that many of these states, I think right now we have 19 states who have enacted red flag laws. And what these laws do is they allow individuals, oftentimes, sometimes it's as close as a coworker, roommates, employers, to make certain reporting on individuals for whom they have mental health concerns. And when these red flag laws come into issue, their immediate activity that can take place. To date, Texas does not have a red flag law. We'll see if that changes in the future. Something else that we've looked into are parking lot laws. They're going to differ significantly from state to state. We've talked about that in the past. With regard to Texas, we look to the Texas Labor Code. And the law is really, at this point, very favorable for the employees who want to have and keep weapons as long as they're in a locked place, such as their automobile, and not directly, you can't necessarily carry your gun into work. That's going to be okay in the state of Texas. And that's something that I know Texas employers are looking at. What do we need to do? How do we need to make sure there are no issues with that? Now, Texas does have provisions with regard to healthcare specifically, and with regard to education. I mean, you cannot take a gun onto a school provision, our school. And this, actually, we're seeing this right here. I think we got a little bit of out of order with our slides, but that's okay. In Texas, for example, in healthcare provision facilities, you would need written permission from the facility itself.
And Tracy, to be clear, this is not an OSHA enforced provision. This is a matter of state law specific to Texas, correct?
That is true. This is going to be state law. Now, some of the concerns, and we're going to get back around to talking about, and yeah, I guess some of it was a little bit out of order, but that's okay. We will, I'll let you go ahead and see if you can get us back in order. But we want to talk in general about how these types of laws affect employers, the things that employers can do to be certain that they're in compliance and doing everything that they can to avoid liability. And I know one of the cases that you heard about earlier today involved Charter Communications, and it was actually an employee who caused harm to a client, not an employee. But I think it's a good example of the types of things that are happening in Texas and really around the nation, and how these types of things, the expectations, how it's viewed by juries.
And I think that's a good point. The Charter case didn't involve violence in the workplace or violence between coworkers, or violence that was perpetrated by someone outside the workplace coming into the workplace. It was violence that was perpetrated by an individual that the employer was then held liable for, correct?
Yes, and I think one of the parallels, you look to these individuals, and as my colleague earlier today pointed out, background checks, what things that an employer may have knowledge of. If you have an employee that comes in and says, I don't feel well, I'm ill. In other matters, we've seen people come in, they say, hey, I'm suicidal, or maybe even homicidal. You know, at that point, there's some difficult decisions for employers to make. And what are the best practices for avoiding potential liability?
Right, and I think from the OSHA standpoint, from a regulatory standpoint, if you're outside, for example, the healthcare industry, where really we've seen from OSHA, and this is referenced in the materials, the most recent cases involving OSHA enforcement have involved the healthcare industry. But if you're outside one of those industries and you have an employee come to you and express a concern about either that employee's own mental health and well-being, or threats or conduct, or just a general concern about another employee, a coworker's mental health or well-being, or the type of conduct that they've been exhibiting, what do you do about that? And I said earlier that from an HR perspective, from a human resources perspective, taking those concerns seriously, documenting those concerns, and then doing what you can to address that employee's concerns about their physical safety in the workplace, that's key.
Yeah, like offering counseling services, having procedures in place, foreseeing that these types of issues can arise and addressing them proactively as opposed to just letting them play out. It's very important, and when you get a complaint or hear something about a particular employee, to investigate and to act immediately, just like with other claims. In this particular instance, it can potentially lead to violence. And particularly with how the laws are in our state, although the great state of Texas has a lot of rights and provisions for our residents, we've got to make sure that it's in line with everything that the employees expect and need for their own safety and personal protection within the workplace.
And I would say that also, if you find yourself navigating a situation like this and you feel as though you lack the expertise, if it is, for example, a mental health issue, you aren't a mental health professional. It is difficult for mental health professionals to identify the point at which an individual who is experiencing some issues mentally, that they are going to turn to violence. That's rare. We know that's rare. In those situations, I think it's important for the employer, our clients, to engage with mental health professionals and to err on that side of caution. You shouldn't have to put yourself in that position of judging someone's state, their mental state. But there are some hooks, there are some signs, obvious signs and some less obvious. But listening to those complaints and expressions of anger, understanding the triggers, the events that may trigger that employee to step over the line. So if you are disciplining, if you are terminating or suspending an employee, those are events that we've seen obviously are more likely to produce these violent events.
Yeah.
So in those
take extra precautions.
Right.
Perhaps have a security guard or even an officer come in to oversee, to make sure that everything stays peaceful and there's a good transition.
Training. Assessing your own the workplace's physical security, changing out locks, for example, if you have a former employee that you've terminated that you have concerns about. Those types of actions, which are, in my mind, a bit of common sense, but those types of actions can go quite a long way to both protecting your employees and reducing your liability.
Absolutely. Well, I think our time's just about up here.
I believe it is.
It's been a great pleasure having the opportunity to speak with y'all, and thank you for your time today.
Thank you very much. Kevin?
And thanks, Tracy and Brian. It's very interesting, heavy stuff, obviously. Lots of tough issues there that are difficult for employers to tackle. But I'll take us back down to a less serious note, I guess, and move on to the next poll question. So our third poll question of the day, following up on the second question, is which of these candies are you hoping do not land in your trick-or-treat bucket this Halloween? A, candy corn, B, almond joy, C, Werthers, or D, Dots? Dots are those candies that are real gummy and sticky and just get caught up in your teeth. Is one of the reasons I'm not a big fan of them, but I'm interested in the audience responses. So we'll go ahead and give you all a few minutes, few seconds to get your responses in, and then we'll move on to our next topic. We got some more results filtering in. Okay. All right. So close race here, but it looks like Dots is the winner on the Halloween candy that you guys do not want to see in your trick-or-treat bucket most this year. I'd probably go with either candy corn or almond joy. As you can probably tell by my comments throughout the presentation today, I'm not a big fan of those. But I want to introduce you to Rufino Gaitan, who is an attorney, a labor and employment attorney in our Houston office. Rufino is going to talk with us today a little bit about political speech and related issues under the National Labor Relations Act or in the National Labor Relations Board. Fun fact about Rufino, tying this back to our previous poll question, he and his wife, when they were potty training their little girl, used to bribe her with candy corn in order to get her to use the restroom. So I was thinking that's probably about the only thing that candy corn is good for around here, but whatever works for you guys. So with that, I'll turn it over to Rufino.
Hi, well, thank you all for joining us, and thank you, Kevin, for the introduction. I appreciate it. So today, I am going to be talking about political speech in the workplace and how certain laws, in particular the National Labor Relations Act, impacts an employer's ability to address political speech in the workplace, as well as some of the, sort of employee relations type issues that might come up when employers are faced with political discussions in the workplace that might, get a little unfriendly between coworkers, or even just that might violate the letter of neutral policy that you have in place as the employer. The other thing that I'll say is, so today I'm going to be focusing on the National Labor Relations Act, which applies to private employers. So if you are a public employer, whether it's a state university or a county or other sort of municipality, these lessons, or at least the risks associated with the NLRA, don't apply to you in general. However, I will address some of the issues that are unique to public employers a little bit down the road as well. But if you are a private employer, the NLRA applies to you almost undoubtedly. There's no employee threshold to be concerned with when it comes to the NLRA. But it is based on whether you engage in interstate commerce. And interstate commerce has been defined so broadly by the federal courts that just about every business is going to be covered by the NLRA. Now, I bring this up only because as long as the NLRA has been in place, we still have employers who misunderstand it to mean that it only applies to them if their employees are covered by a union. And that is not the case. So the NLRA's protections apply to your employees as a covered employer, regardless of whether those employees are represented by a union or not. The exclusions are, supervisors, confidential employees. Those are employees who are not covered by the act, but non-supervisors are covered. And the reason it's important to keep that in mind is I was actually just speaking with a fellow labor lawyer a few weeks ago, and she does nothing but NLRA, NLRB proceedings. And she was telling me that she had on her desk at that time 5 different unfair labor practice charges from 5 different clients, all of which addressed violations of the act based on an employer disciplining the employee for discussing his or her wages with other coworkers. I know that a lot of our clients come to us as well with this concern. They say, we want to offer this person, X amount of salary plus a bonus. What can we do to keep that information confidential? If the employee is not a supervisor and is even an hourly employee, for example, those sorts of discussions are protected under Section 7 of the NLRA, and you cannot prohibit employees from discussing those sorts of issues with their coworkers. So it's just important to keep that in mind. Very general applicability for the Act. All right, so what is protected specifically? So the right to form or join a union, protected concerted activities to address working conditions. This is what typically trips up a lot of our clients and a lot of employers in general is, what is protected concerted activity? It can take the form of an employee speaking on behalf of other coworkers. So if a single employee comes to your HR office and says, I was speaking with Jane Doe and John Doe, and we all agree that our wages should be higher, for example, that is protected activity, even though it's a single employee. The other version of that could also be a group of employees engaging in activity where they are discussing the working conditions or their hours. They maybe are unhappy with their schedule. That is also protected concerted activity. And then the other thing that the Act protects as well is the right to refrain from engaging in those activities. Where this comes up typically is, or violations of this provision come up, are where an employee might not want to address certain issues, or they might feel pressured by a supervisor to, counter message employees who are unhappy with the working conditions. So it goes both ways. Employees have the right to engage in these activities, and they also have the right to not engage in any of those activities. So currently, the NLRB has had a fairly recent change at the general counsel position. The general counsel is a woman named Jennifer Abruzzo. She's a former attorney for the Communications Workers of America. She's got a lot of experience in this area, but mostly on the union side of the equation. The reason it's important to understand who she is and her background is that the general counsel for the NLRB really does set a lot of the national policy when it comes to labor matters. The quote that you see here on the screen is actually a quote that Ms. Abruzzo said during her swearing-in ceremony as general counsel. And as you can see from her philosophy, she is all in on protecting workers, on doing what she can do as the general counsel to drive policy to ensure that employees have what she refers to as a level playing field. I know from a lot of our clients' perspective, it feels, especially if you've had any experience with the NLRB recently, it feels that the playing field is actually tilted in favor of unions and employees. And while that might be the case, that is something that is being driven by this general counsel, and it's why it's important to understand where she's coming from. So the way that Jennifer Abruzzo is prioritizing certain policies is with her stance is that she believes that political speech in the workplace, needs to be protected in some way. And what I'm showing you here is actually the results of a poll from 2019 that was conducted by SHRM, the Society of Human Resources and Management. Just last week, actually, SHRM released an updated poll. So there's a more recent version of this in which some of these numbers were updated. So the latest numbers are that 24% of people believe to have experienced political affiliation bias in the workplace. So that number has doubled in the last 3 years. That should be a concern for you as employers, because even though federal law doesn't protect political affiliation as a protected status, if you are creating an environment as an employer where people believe that they're being treated unfairly or differently because of their political views, that's going to lead to discord. Eventually, it might lead to a legitimately hostile workplace, even if it's not one that is protected by law or prohibited by law. It still leads to employer relations issues. It's going to lead to dissatisfaction with you as an employer, and it inevitably will also lead to the types of claims that I think you've all come to fear and understand, that are claims of discrimination that really don't have a basis to them, but there's an environment in which the employee is made to feel that way. So just important to keep in mind, obviously political discussions have become much more common in the workplace, and they are something that all employers need to consider. From the NLRB's perspective, and this is another quote from Jennifer Abruzzo, she believes that political and social justice advocacy, where the subject matter has a direct nexus to employees' interests as employees, is protected concerted activity. This is a quote from a speech she gave in October of 2021 at Cornell University. And again, it just highlights her ability as the main policy driver for the board in trying to choose the issues of the day, right? So she is highlighting this issue as something that is important to her, and we're starting to see that play out across all of the different regions of the National Labor Relations Board. So what does that initiative or that policy priority cover? According to Jennifer Abruzzo, and again, a lot of the regional directors, they all take their direction from the general counsel. They are looking at things like the Fight for 15. If you remember a few years back, that became a really hot topic in the workplace. Employees were out, protesting and trying to fight for a federal minimum wage of $15 an hour. Even though that didn't come to fruition, engaging in those activities does have a tie to the workplace, right? Whether it has a connection to your workplace or not, Jennifer Abruzzo's point of view is that because it's a workplace issue, it deserves protection under the Act, and she's going to prosecute, disciplinary issues that are based on these sorts of activities as unfair labor practices. Another topic might be immigrant rights protests. So you might wonder, well, what is the connection between somebody's immigration status and the workplace? If you are dealing with farm labor or temporary labor from employees who require immigration visas or even DACA status, right? So if you're an employee who is supportive of improving somebody's ability to work in the United States lawfully, Jennifer Abruzzo says that is protected concerted activity. If you discipline an employee for engaging in those sorts of activities, you're committing an unfair labor practice. And then the last example that I have on here is Black Lives Matter protests. So this actually leads to this issue where there are a lot of you that have policies, and some of them were even drafted by us, that include dress codes that prohibit things like wearing any sort of paraphernalia that's not work-related, right? So you don't permit employees to put buttons on their uniform. You don't permit them to wear T-shirts with slogans, those sorts of things. And they're on their face, even, doesn't matter what the message is, you prohibit any sort of messaging. Well, according to Jennifer Abruzzo, and this is actually a case that has come up in a Home Depot matter, where an employee was wearing a Black Lives Matter button in support of the movement soon after some of the protests that erupted in Minnesota. That employee was talked to by the manager at his location, and the manager said, "We need you to stop wearing that button. It violates our dress code policy." The employee refused to remove it, and in the process of trying to come up with a solution, the employee ended up just resigning. So the regional director for that Minnesota office, or the Minnesota region, filed a complaint against the employer, claiming it was an unfair labor practice to require the employee to remove the button. Ultimately, the administrative law judge determined it was not an unfair labor practice because although the Black Lives Matter protest deals with issues that are very important to a lot of people, but in particular African-American people, and even more specifically, African-American men who are mistreated by police, right? The fact that that is an issue that is important to other coworkers doesn't automatically make it protected, because as the judge said, there is no connection between how African-American men are treated by police to the workplace conditions at this particular location. So Although Home Depot won at this stage of the proceedings, that matter is up on appeal. It's going to be taken up by the National Labor Relations Board, which will make a determination that will be, in theory at least, binding on every employer in the country. So more to come on that issue. But one of the other things to consider when you're dealing with these sorts of discussions in the workplace is, if you're going to permit them, where do you draw the line? So for example, what if an employee wanted to wear a button that had a Confederate symbol on it, or maybe it's the Confederate flag, whatever it might be? If you're going to let somebody wear one thing, it becomes very difficult for you to then prohibit other types of political speech. So when doing those sorts of things and having those conversations amongst your management team, you need to consider other laws, right? So what about Title VII, for example? So what are the implications of you allowing somebody to wear a Confederate symbol or a white supremacist ideology or something that professes some type of political speech that might be offensive to a great majority of your workplace? Once you start to treat people differently based on the message itself, that is where employers will run into problems generally, even outside of the NLRA. So from a Title VII standpoint, it becomes a discrimination issue. Are you allowing white employees to do certain things that you don't allow minority employees to do, or vice versa, right? So either one of those scenarios is problematic from an EEO standpoint. So again, the issues are going to vary depending on the message itself. They're going to vary depending on your actual policies. Are they neutral on their face? Are you enforcing them consistently? All of those are things that you need to consider when you're creating your own policies and preferences for your own workplaces. So in terms of how Jennifer Abruzzo is kind of, making you pay essentially as an employer with these directives, is the NLRB has very wide discretion in creating the types of remedies that it believes will make the employee whole. So if you violate somebody's rights or allegedly violate rights of an employee, the NLRB through the regions are going to come after you for back pay, for example. But in addition to that, they might come after you for things like, this person missed a mortgage payment because they didn't have income from their job because you terminated them. Jennifer Abruzzo is urging all of the regions to go after those types of remedies as well. But the really big issue that she has focused on is she is insisting that all the regions go for 100% recovery on back pay. Now, you might ask yourself, if I'm going to have to pay 100% of what I allegedly owe somebody, what is the downside? What do I have to lose by fighting this out and taking my chances? Well, that is a very fair question, and it's actually one that is coming up and has become a reality for us. I've got a handful of matters currently where that is the issue, is a client is telling me if they're going to insist on me paying everything I supposedly owe this person, why wouldn't I just take the risk? My message to you and for you to consider is, consider the disruption that going through this litigation will create. It's going to take your supervisors and some HR personnel out of their daily routines. It's going to be disruptive in that sense. But on top of that, if you do end up losing, then the regional directors will have the opportunity in litigation to create an even broader remedy request. So it's not just that you're looking at 100% payment at the front end, but on the back end, there's also the risk that you're going to see an even steeper bill, not to mention the cost of defense too, right? So you're going to have to pay your attorneys their fees for potentially what might end up being a losing effort. And then, of course, there's the broader, more practical implication of, even if you win at a hearing, if that matter gets appealed to the board, maybe it's just the cynic in me, but I can almost predict that the outcome at the board would not be favorable to you, and it would probably be a 3-2 vote in favor of the employee as well. So it's just the reality of the times, unfortunately. So how do you avoid some of these issues in the first place? What are some best practices? So one of the things that tends to get lost in the shuffle a lot of times in these discussions is, what is the type of culture that you want to create as an organization? If you have a philosophy where you allow people to have these sorts of discussions in the workplace, then you can continue to do that. If you want to be open about, political preferences and things like that, that is okay too. You just have to make sure that when you do that, you consider some of the other risks, right? So are you going to create potential friction in the workplace? And if so, what do you do to address that? What are the implications from a Title VII standpoint? My general rule of thumb for clients is, if you find yourself between a potential violation of the NLRA with an unfair labor practice charge, but that might eliminate the possibility of a discrimination claim on the other hand, you're choosing between the lesser of two evils. And unfortunately, the lesser of those two evils is go ahead and violate the NLRA, because the Title VII damages are probably going to be significantly higher. But so consider those issues as you're creating your own policies. But then the last thing, of course, is maintaining consistency in how you address workplace discussions that are political in nature. Don't pick winners and losers. Be consistent. If you discipline somebody for wearing a MAGA hat, you need to discipline somebody for wearing a Beto hat. Like, you have to be even-handed in how you address all of the issues. The moment that you deviate from that consistency, you're more than likely going to see some discrimination type claim or an unfair labor practice charge as well. So with that, thank you all for your time today, and I'll turn it back to Kevin.
Thanks, Rufino. Yeah, it's always interesting to me how the pendulum swings back and forth towards the employer or employee side, depending on, who's in our presidential administration, or, who that person may appoint as leaders for some of these government agencies. But we're now at our last and final topic, which also means we're at our last and final poll question. So poll question number 4, last one of the day. Which of the following would scare you the most? A, walking through a graveyard at midnight. B, being chased by zombies. C, running out of candy when the doorbell rings. Or D, a supervisor firing an employee without consulting you and HR. I know which one would scare me the most, but I'm interested to see what your reactions are. So we'll give you a few seconds to let you get your answers in, and then we'll move on to our last topic. We've got a few more answers coming in. All right, so as I expected, yeah, the last answer there, supervisor firing an employee without consulting human resources is overwhelmingly the top choice. But yeah, B, being chased by zombies would be pretty terrifying too, I guess. So our last topic of the day, Kayla Lovelace from our Houston office and I are going to talk about employee post-pandemic mental health issues and related legal considerations. So Kayla is a labor and employment lawyer in our Houston office. We work together frequently, and I asked her about her favorite Halloween costume this morning before the presentation, and she told me that it was when she dressed up as Hermione from Harry Potter. And I'll spill a little dirt on myself too, I guess, because last year, me and my family dressed up as the Harry Potter crew. I was Dumbledore, Kayla, if you can believe it or not. So anyways, with that, I'll kick it over to Kayla, and she'll start us off on our last topic.
Thanks, Kevin. So like Kevin mentioned, today he and I will be talking about the COVID-19 pandemic and its aftershocks. As we are all aware, following the COVID-19 pandemic, there were a lot of changes across the world, but especially within the field of labor and employment. One of the things that we've seen happening in 2022 is that there is a decrease in employee mental health. For example, there have been reports that employees are having decreased perceptions of safety. They feel isolated. They feel excluded on a social level. They have jobs insecurity and other negative feelings associated with that. They're anxious, depressed. there is an increase in the abuse of substances and also other cognitive issues, including brain fog, confusion, and forgetfulness. And so this is important from a labor and employment perspective because caring about an employee's mental health and also providing services for employees and teaching your management how to manage issues that might arise from poor mental health is really important for business. It just makes sense. Employers who have these services in place for mental health have seen overall increased revenue, increased retention, increased productivity, and overall company loyalty from employees. And so beyond just the business justification for caring about an employee's mental health, there's also a legal justification for it as well. So even before the COVID-19 pandemic, the EEOC had already taken the position that if an employee is in need of an accommodation of remote work that is proper, to the extent there is no undue hardship for the employer, as well as if the employee is still able to complete their essential job functions. Now, after the pandemic, the EEOC has now taken the stance that some employees who might have had some pre-existing mental health conditions like anxiety, depression, OCD, PTSD, and things like that, they may actually be entitled to a reasonable accommodation. And so what this means is that first, remote work can be seen as a legit reasonable accommodation, and also that mental health issues should be taken seriously by employers so they are not liable under the ADA. And so some of the things that employers should keep in mind when it comes to handling these issues is to have a conversation with the employee to figure out whether or not their disability is actually considered a disability under the ADA. Also consider some alternative accommodations for that employee because, you know, remote work may work. Maybe putting an employee in a different office away from others might also work. So have that conversation, engage in the interactive process, and also just essentially, you know, you can request medical documentation from the employee as well to the extent there is a need for certification of the mental health issue. And so this is not something that we're just telling you all. It is something that the EEOC is really taking seriously. As recent as February 2022, the EEOC actually sued an employer. And in that case, the employer actually permitted the employee to take leave pursuant to the ADA. However, upon return to the company, the employer fired the employee, stating that they no longer could trust the employee to do their job. And so, of course, they were seen liable under the ADA, and the employer paid out $250,000 to settle that case. And so it's really important. You don't want to expose yourself to any legal liabilities. And so we've kind of talked about some of the benefits of remote work and how it can be useful for employees who are suffering from mental health issues, but there also are some cons to remote work as it relates to mental health. And so we have all been experiencing this pandemic together. So we are aware that, you know, back in 2020, a lot of major companies made public statements saying they were adopting the hybrid model, or they were allowing employees to choose when they work in office or work from home. In mid-2021, the return to work efforts kind of increased, and more employers adopted the same initiative. They allow individuals to work from home and to have more flexible schedules. And so there are many pros to having this type of hybrid model. So it offers more flexibility. It is very attractive to some of the younger individuals in the workforce. So millennials and Gen Zers really seem to enjoy the flexibility of a hybrid model or working from home. Additionally, there is some increased productivity and there is increased employee morale. And overall, it just lowers an employer's overhead costs. Like I mentioned earlier, there are some cons to this hybrid model. Many employees, especially employees who are salaried, they often say that working from home or working on a hybrid model can lead to burnout. They no longer feel like they can leave work at work. They're bringing work home, and they also feel like they have to be accessible at all times. Additionally, there is an increased reliance on technology. We're doing videos via, Zoom and things like that, and some people just prefer to have in-person contact. Additionally, there is a decreased collaboration because individuals are working from their home. There's not much need for people to come in office, or some individuals feel like there's no need for people to come into the office as much. And so we just want to keep that in mind. Although hybrid work has definitely presented a lot of benefits, there is some negative things that have been associated with, so keep that in mind. And so before I turn things over to Kevin, I do want to talk about an employment trend that started in late 2021. At this time, we are still in the midst of it, but some people believe we might be near the end, and that's called the Great Resignation. And so The Great Resignation got its name because in late 2021, resignation was at an all-time high. Some of the reasons that contributed to the resignation include burnout, better pay opportunities for others at different positions, excess job opportunities. So many people felt like there were more jobs than people who wanted to actually work, and an overall shift in culture for working because there are more Gen Zers and millennials who are actually entering into the workplace. And so it has been shown that Gen Zers and millennials they prioritize other things outside of work above work and pay and things of that nature. And so we just have some advice when handling these issues and how to increase your retention. The main thing here is first to encourage collaboration. We see that there is an increase in retention as individuals feel a part of a team, part of a family, and when they get to know the people that they work with. Next, foster a collegial environment. Be sure that you're treating your employees great. That sounds something that, we all should know, but we do want to reinforce, treat employees nice, make them feel welcome and things of that nature. And last but not least, implement DE&I initiatives. A lot of the individuals, along with the millennials and Gen Zers who left within the Great Resignation were diverse candidates for employment. And so we definitely want to, implement DE&I initiatives. They allow an increase in retention of diverse employees across the board. At this time, I'll turn things over to Kevin and he'll talk about more employment trends.
Thanks, Kayla. You can run it if you like. So in 2021, like Kayla's saying, we saw the Great Resignation. That's sort of calmed down a little bit. I at least in my practice, I'm still have clients that are experiencing quite a number of people leaving, but still maybe not as many as were in 2021 when it was at its all-time high. But what we've seen recently has become a topic of discussion is this idea of quiet quitting that's come up in 2022. When I first heard the term quiet quitting, the first thing that popped into my mind, because I'm not on TikTok looking at all these videos that are talking about quiet quitting, was, okay, is this somebody that's like giving their notice to their employer that they're leaving and just sort of ghosting and not, communicating to their coworkers that they're leaving? Is that quiet quitting? That's not what this is talking about. Quiet quitting, like I said, it's a term that popped up on social media, I think probably TikTok, in late 2021, early 2022, and it's really been gaining steam. There's no real, concrete definition behind the term. There's a bunch of different ideas about what quiet quitting might mean, but generally it's not people or employees quitting their jobs. It's employees who are deciding, I'm not going to go over and above and do what's, more than the bare minimum necessary to keep my job, to keep my employer happy. So they focus on doing tasks that are, only specifically identified in their job description, or things that they, if they're being asked by their supervisor to do something that may go over and above what they normally do, they may push back and say, that's not part of my job, I'm not going to do it. Others refer to quiet quitting as sort of people that are, seeking more of a balance, kind of what Kayla was talking about with the Great Resignation, between their work life and their home life. Remote work, especially, I think, has made that much more difficult to draw that line there. I know during the pandemic, when I was working from home all the time, it was difficult sometimes to turn it off and, leave my workspace in my house and go spend time with my family, because, I was used to having that downtime, driving in my car back from the office or whatever, where you can kind of mentally reset and, focus on home life instead of work life. That's become a struggle for some people. So employees, really both of these things, I think, are, generated as employees sort of trying to prioritize their well-being, their mental health. They're putting themselves first instead of their employers first. Like the Great Resignation, we're seeing this, and you can tell by my snide remarks about TikTok, I guess, that this is more amongst the Gen Zers, the millennials. This is really important to them. Their priorities are shifting, and because of the Great Resignation, our workforce has become a lot smaller, and it's important for employers to identify these issues and try to be proactive about them, because given the smaller nature of the workforce, if you have people that aren't doing their jobs to their fullest ability, it's going to impact your bottom line. When you think about it, quiet quitting, in my mind, it's a new term, but for an old behavior. For years, I mean, we've heard about employees who are not engaged in their jobs or who, would rather be doing something else. It's just, this has become much more prevalent on social media, and, all the influencers and stuff out there are talking about it. And so it's bleeding over into the workforce much more than we've seen in the past. Important to pay attention to the trends there. On the slide, you'll see in 2025, millennials are projected to make up to 75% of the global workforce. And so you may be thinking, well, so what? This is what the Gen Zers and the millennials think, like they'll move on to something else. Those employees are if they're not already, they're going to quickly be the majority of your workforce. So it's important that you pay close attention to this issue. So what do you do to manage quiet quitting? How do you deal with it? I think first it's important to understand the whys behind quiet quitting. Why are these younger, Gen Zers, millennials in the workforce, and others too, it's not just them, why are they, taking this sort of action? I mean, I think a lot of it, a lot of research has said it's because they're inundated 24/7 with work communications, whether it's meetings at work, in the office, or a meeting on Zoom, or getting an email from their boss at 11 o'clock at night right before they're going to go to bed. I know that can be frustrating, as you get an email and you feel like, well, couldn't that have waited until tomorrow? Those are the sort of things that I think kind of lead to what can be considered a poor organizational culture, make people feel that they're not valued at work. Lots of people get a lot of their self-worth from their job. And if they're feeling like they're undervalued, that impacts their mental health. Being underpaid, overworked, again, because we're dealing with staffing shortages, a smaller workforce generally, lots of employees are getting paid the same amount, but being asked to do a lot more. And so that's where, this quiet quitting comes up. How do you handle it? I mean, it's not easy, that's for sure. I think, being really conscious of trying to manage the workflow, to accommodate employees to have time, even if they're working from home, to have that separate, time that's away from work at their house. So if you're a supervisor, you may think about, do I really need to send this email at 10:30 at night, or can it wait until the morning? In all likelihood, unless it's something really urgent, it probably can wait until the morning. And so you take that away, that thing away, and that makes employees, feel more valued, because you're not asking them to work all the time. Minimizing unnecessary meetings, other activities that pull employees away from work. That's important too. One of the constant complaints I hear, from HR and other folks, is that there's just too many meetings. That meeting could have been an email, right? So eliminate those unnecessary meetings. I think that delivers more value to the employees. Back to the job description thing, because folks are focusing so much on, well, that's not in my job description. You need to make sure that your job descriptions entail everything that person is supposed to or is responsible for doing. That helps avoid this issue of, I'm not going to do that because that's not part of my job. Obviously, if it becomes a bigger issue, you've got to consider discipline, what to do about it. Performance improvement plans, corrective action plans are important to set expectations and to hopefully manage those issues going forward. Ultimately, if you're not able to resolve them, you may end up in a situation where you have to terminate, but hopefully that's not what you get to. So second topic that we've seen a lot out of post-pandemic is employee migration to Texas. You hear all the time about people moving to Austin or Houston or Dallas, wherever it might be, from California or New York, because, one, they're coming to Texas because we don't have a state income tax is a big benefit, but two, they're able to do their jobs remotely now, right? And they can do them from anywhere. And so why not come to Texas or somewhere else where they're closer to family? So we've seen a lot of employees coming into the Austin market, for example, big tech scene here, lots of tech employees from California coming on board. And I think it's just going to continue to increase. So when we're thinking about that, I think we need to think about what are the legal issues that might arise out of this employee migration. Would you go to the next slide? So remote workers, whether it's somebody coming from California to work in Texas remotely, or what I see more often in my practice is clients asking questions about well, we've got an employee in Texas who wants to go, live in New York or California or Oklahoma or wherever it might be. What do we do about this? Oftentimes, it's an issue that you can solve and get the employee to work where they want to work. But oftentimes, there are lots of legal considerations that our clients sometimes haven't thought through before they approve that sort of move. So, for example, if you have somebody who's traditionally worked in Texas who decides I want to relocate to California, if they're living and working in California, even though they're directing their services to Texas, California law is going to apply to that employee. And then so you get into issues of, okay, well, should we be withholding state income tax for this employee working in California? Are we registered to do business or to withhold payroll taxes in California? What does California require from a workers' compensation perspective? If we have a certain threshold of employees in California, are we establishing sort of that statutory tax nexus that might require the company not just to withhold employee wages for taxes, but also to pay their own taxes into that state? Non-compete issues, California, this is just an example, California doesn't permit non-competes. If you have an employee that has been working in Texas for 10 years and signed a non-compete agreement 10 years ago, and you say, okay, you're good and you can go now work and live in California, California law is going to apply to that person going forward, right? And so you're probably not going to be able to enforce that non-compete agreement that you'd otherwise be able to enforce. So there's a variety of tax and legal and other issues to take into consideration when you're considering this sort of out-of-state remote work for employees. I think it's really important for employers to stay on top of this. Put a remote work policy in place if you're going to allow it, that governs, this is what the relationship is going to look like. It needs to say if an employee is going to relocate, they need to provide advance notice of that to the employer, so that then you can go to your outside legal or your consultants and CPAs and determine, okay, what does this mean for us as a company if this employee relocates to California? What additional obligations is that going to create on our behalf as an employer? So staying on top of that, thinking through those issues, very, very important. I think it's something that a lot of people didn't necessarily anticipate as part of the pandemic, but it's become a big, big issue. So I'll turn it back over to you, Kayla.
Thanks, Kevin. So Kevin and I have a couple of scenarios we want to walk through with you all. We pulled these scenarios from real life advice and counseling that we've given to clients. So for scenario one, we have Julie. She suffered from anxiety and has worked remotely since the beginning of the COVID-19 pandemic. Julie's employer announced its expectation that employees return to work on a full-time basis at the end of the month. So Julie responded and submitted a letter to her manager indicating that she would not be returning to work in office due to her anxiety. What are the employer's obligations when managing this request? And so you can answer this at home. You can hop in the chat if you want to, and we'll work through this together. So first, the employer may request medical certification of Julie's alleged disability. Next, the employer can also should engage in the interactive process with Julie pursuant to the ADA by discussing the potential accommodations available to Julie. And while engaging in this process, because Julie is already working remotely, we highly recommend that the employer permit her to continue to work remotely until a resolution is actually reached. So I'll pass things to Kevin.
Yeah, and I'll follow up on that just a little bit. I mean, I get this question all the time in my practice now. And it's because I think employees got so used to working remotely from home. Some people don't like it. Some people really like it and want to continue doing it. And I've got some clients who say, we're not going to allow people to work remotely. They need to be in the office. And so then the sort of, the way to get around that for an employee is to, say, well, I've got a disability and I need to be accommodated for it. And the accommodation I want is to work remotely. Just because they ask for that accommodation doesn't mean that this accommodation you have to give them, right? It has to be something that's reasonable. I had a client call me yesterday about an employee who was experiencing back pain and neck pain, and said, it would be really beneficial for me if I could work from home instead of coming into the office for that. And the client said, well, let's talk about this. Let's try to further understand, what is it that you're, struggling with? What are your job functions that you can't perform in person because of your disability? And the employee said, well, it's hard for me to walk up and down the stairs, and it's hard for me to sit at my desk for an extended period of time, and sometimes I need a chair that reclines. Well, so that client determined, well, instead of working remotely at your house, we still want you to come into the office, but we're going to give you a reclining chair, and we're going to move your desk where you don't have to walk up and down the stairs. And taking those sort of issues into consideration, they were able to find an accommodation that they viewed as reasonable, that solved the problem, but didn't have to have the employee working remotely. Of course, the employee wasn't happy about it, and I think is going to go back and ask for another doctor's note to try to come up with some other rationale why she should be able to work remotely. But anyways, very common question, something that we deal with all the time these days. We want to go to scenario number 2. So let's see. I think we went out of order a little bit. There we go. Okay, so scenario number 2. Mark is a salaried employee who's decided to engage in quiet quitting, like we were talking about. Mark's supervisor, Terry, has requested that Mark work on a Saturday morning to complete a project. Mark responds to Terry that, I'm not going to do this project because my job description does not require that I work on the weekends, even though he's a salaried exempt employee. Terry decides, you know what, I'm not going to put up with this. Mark's not going to tell me that he's not going to do his job. I'm going to discipline him. So what are Terry's options here? What do you think, Kayla?
Well, first, definitely consult with HR. We have to confirm that Terry is aware of Mark's actual job duties and to confirm that the request is actually within the realm of his job scope. Yeah.
And I think also, Terry talking to Mark or other folks about, what's your workload like? Is it really manageable? It's not an obligation, legal obligation, of course, but it is a best practice to try to understand. I think it goes a long way from an employee relations perspective too, to try to, sympathize with the employee, right? And so, what is it that, is that you're so busy with? But either way, if Terry is going to issue discipline to the employee because of this, it needs to be pursuant to the company's disciplinary procedures, whether it's coaching, counseling, corrective action, it could be up to termination. The important thing, though, is to make sure that Terry and HR are treating Mark the same way with regard to this as they are every other employee. Otherwise, you're going to open yourself up to a potential discrimination claim.
Definitely.
Any other thoughts on that?
Well, like our first scenario, we've definitely had questions and cases that are exactly on point with this. So this isn't just something we're telling you all. This is something that's happening within the workplace. So definitely be on the lookout for these issues.
Absolutely. All right. Well, with that, I think we're about out of time. So I'll go ahead and close us out. Thank you for joining us today. We hope all the information today was helpful for you and your organization. As a reminder, this program has been approved for HR and legal education hours. So to report those, make sure you click on the CEU icon at the bottom of your screen. As I think I said at the outset, a certificate of attendance will be emailed to you along with the course numbers either later today or tomorrow, along with the recording of the webcast so you can play it back or share it with others if you'd like. Also, again, please be sure to complete our short survey at the end. We really do value your feedback, and we use that to tailor our future seminars to try to address issues that you guys want to hear from us on. So that concludes our program for today. Thank you so much for attending, and have a good rest of your afternoon.